Good evening and good afternoon, good morning and namaste to everyone from India who are joining us for this web event from different parts of the country and from different time zone. I, on behalf of Nivaran, a collective of Supreme Court Mediators Association, heartily welcome you all along with my co-host for today, Ms. Praveena Gautam, Advocate Mediator, Supreme Court of India. Today's topic of the web event is of immense relevance, the importance of mediation, increasing importance of mediation in global society with respect to education, security, justice, and commerce. And to give us an insightful session and a very good talk on this, we have none other than Mr. John Bussey, who is an amazing person, an eminent personality, having an illustrious contribution in the field of alternate dispute resolution, arbitration, and mediation. Once again, welcome Mr. John Bussey on behalf of our team Nivaran, Supreme Court Mediators Association, for joining us today, sparing a valuable time to be with us to mark his presence and participation for this web event. So just to inform our participants that this is our 9th lecture in the series, which is organized by the dedicated and committed team of Nivaran. It's their initiative to share knowledge, to spread awareness about mediation, more education about mediation so that people realize in society on the globe the importance and contribution of mediation in today's time. Yes, mediation has increased. Its value has increased manifold. People have started accepting it as one of the most appropriate, proportionate, prudent choice to resolve your disputes. There's no doubt about it. We had witnessed times and era wherein ADR was synonym to arbitration. Arbitration, a dispute resolution mechanism. It was basically because of the two mindsets. People always had a belief that if your dispute is adjudicated by someone who holds a chair of authority, there is a legal sanctity attached to it, then there is more credibility and sustainability to the resolution of dispute. And even we had a mindset of people wherein they preferred competition, confrontation with their counterpart, wherein they always felt that it is good to prove one as right, the other as wrong. But no, time has changed. We are in an era wherein people, more specifically after pandemic COVID-19 devastating effects on the precious lives of many of our close relations and on our pockets, we have a weakened economy. People are looking for a peaceful resolution where they have stability, where they have harmony in their relationship, where they can preserve, restore peace amongst themselves. What better we can have other than mediation to serve this purpose? A peacemaking process, a process which has many benefits, benefits which have really benefit many communities, societies, organizations, schools, educational institutions, business organizations. And the success, whatever we have about mediation on the globe today, it is also because of the contribution of the legal fraternity and our judicial system in accepting with open arms about the relevance and importance of mediation. Here in India, mediation has also made a progress, not just because of the fact that we all are contributing to this, but we must applaud from India that even in the absence of uniform code of conduct, a mediation law, we are able to fill this legal vacuum because of the motivating support of our court, our honorable judges. They have referred matters for mediations. They have given landmark judgments wherein they have given suitable cases which can be marked for mediation. We have various enactments, timely amendments also, which support mediation and conciliation as one of the means. We have industrial disputes here in India, which has conciliation provisions. We have amendments in our Companies Act with mediation and conciliation rules. We have recently witnessed amendment in our Consumer Protection Act. We have witnessed development in our Real Estate Regulation Development Act also. there are various ways, the way India has embraced, since we have various participants from various region and countries of this globe. I, on behalf of India, can tell more about how India is progressing, has opened the landscape of mediation here in India with the support and collaboration of each one of us. Everyone has contributed. Mediation makes sense in every part of our life, at every age of our life, be it childhood or an older life. Yes, we have countries who have adopted mediation in schools. They are educating pupils to communicate better, to empathize with others, to respect the other point of view. Yes, we have schools wherein we teach children to just talk about their concern, to raise their voice as to their needs, not as to their wants. So that is the beauty of mediation. Not just advocates, but yes, in schools also, mediation has a lot to do. Even in colleges, we have mediation. In India, to inform our guest speaker of the day, Mr. John, in India, our apex body, Bar Council of India, has now made mediation as one of the mandated separate subject of curriculum of LLB students. That's the power and beauty of mediation. Yes, it is widely accepted as a platform, a secured platform wherein people internalize their disputes, internalize their needs, and want to sit across with the counterpart in a timely and a cost-effective manner. Yes, it has really made so much of changes. And judiciary, justice, yes, our courts are supporting us day in and out. We have various mediation enactment in various countries, and soon India will also be gifted with a mediation enactment with various provisions. Yes. Even in commerce, in commercial dispute, there is a significant change internationally. We have Singapore Convention. In India, we have amendments in Commercial Court Acts, wherein now it's made mandatory for the people who are looking for a redressal of their commercial dispute to first go to the desk of pre-litigation mediation. There is no obligation on them to participate or to mandatorily sit in this, but yes, they have to file a litigation, pre-litigation mediation there before they redress for it. It is mainly because there's so much of cost cutting involved. Arbitration has its own roadblocks and challenges. There is no certainty, because once there is an arbitration award, there is challenge as to its execution. You can challenge award on various grounds, and then the cost of arbitration. These are the factors which has really ushered, which has put mediation on a plateau wherein we today can certainly say that mediation is the most appropriate dispute resolution mechanism, a peacemaking mechanism. And we can say that our generation next not only be the prophets of peace, peace builders and makers, but I would use the word today, let us be peace bakers. Let us sit in harmony. Let us just curtail cost. Let us just curtail uncertainty. Let us just sit across, be it any community, be it any sector. Mediation is the need of the day. So before I welcome our chief guest, our guest of speaker, Mr. John Vesey, to share his insights on the topic of the day, I would like to briefly introduce Mr. John Vesey to our audience who are joining us from different parts. And before that also, let me take a liberty to just inform our participants that after the talk of Mr. John Vesey, we will have a quick question and answer session too. And kindly please post your questions in the chat box, which me along with my co-host Praveena Gautam would happily take it to our guest speaker, Mr. John, and get them answered. So please, participants, be attentive, be participative. We are here to learn from each other. Mr. John Vesey, let me, though the words are not sufficient to introduce you, but due to paucity of time, still we would like to introduce you to our audience. And before I introduce, and I would inform everyone to congratulate Mr. John Vesey for being elected today on 4th July 2021 as the Vice President of Jamaica Bar Association. That's JAM Bar. So it's a lucky day for each one of us that our chief guest has got a good news to share with us. Again, a huge congratulations to you, Mr. John. Mr. John Vesey, he's a global vice president of Chartered Institute of Arbitrators for the year 2021. He will be the Deputy President for the year 2022 and Global President for the year 2023 of the Chartered Institute of Arbitrators. Mr. John Bessie was called to bar in England in 2003 and to Jamaica in the year 2004. In addition to being a former council member of Journal Legal Council, he was the chairman of its subcommittee with the responsibility for formation of compensation fund. Mr. Bessie is also a treasurer. Earlier, he was serving as treasurer of Jamaican Bar Association. So today he's been elected as vice president. That's again a good news. He's also a chairman of ADR committee. Mr. John is founder of Caribbean branch of Chartered Institute of Arbitrators 2009 and was the first chairman of the said branch. He is also a chairman of the board of Dispute Resolution Foundation, which is the oldest ADR organization in the Caribbean region, having just celebrated 25 years of its service in mediation in the industry. He is the chartered arbitrator, certified tutor of Chartered Institute of Arbitrators, a certified mediator, both at Supreme Court of Jamaica and Supreme Court of State of Florida. So here we have our chief guest, our speaker of the day, Mr. John Bessie. Floor is with you, sir. You're most welcome. And once again, we welcome and convey our gratitude for sparing your time and coming for this on behalf of our team, Nivaran. Thank you so much. Floor is with you, sir.
Thank you very much, Push. Thank you very much for allowing me the opportunity of spending my morning with you. Here in the Caribbean, before we get started, we are experiencing some inclement weather. And it's got quite rainy outside and thundery. So if you hear me lift my voice at times or something happens, it's because of the weather. I also want to take a little bit of time out before I start to recognize all of us, because I know that in one form or the other, we have been affected by the pandemic. We are very thankful. I'm very thankful to be here this morning. And I also am thankful to be here with my fellow human beings to share some insights with you. Basically, I also want to say happy Independence, 4th of July to our American persons who are in the audience. I guess you're celebrating quite a few more years than us, but this morning, but congratulations to you all. This morning, I would like to first and foremost start formally by recognizing Rakesh Khanna, the past president of the Supreme Court of India Bar Association, Githendra Sharma, past vice president of the Supreme Court Bar Association, Santam Krishnan, past president of the Commonwealth Lawyers Association, and I believe one of the conveners of this meeting, Kush Gupta, senior advocate, mediator and trainer. Push was the one who presented this morning, and thank you, Push. Pravina Gautam, senior advocate and mediator. Members of Nivaran, mediators of the Supreme Court of India, my fellow ADR practitioners and colleagues. Distinguished ladies and gentlemen, Namaste, or as we say in my part of the world, one love. It is indeed my pleasure and honor to be here today and to speak with you on the topic of the increased importance of mediation in global societies with respect to education, security, justice, and commerce. I want to first start off by recognizing the Mediation and Conciliation Project Committee, MCPC, that was set up by the Honorable Chief Justice of India in 2005, specifically to encourage the amicable resolution of disputes within the civil courts. Thanks to the organization, mediators and advocates like Santhan, Rakesh, Githendra, Push, and Pravina, MCPC project were able to initiate a court-integrated project that has proven very successful and has conducted many training programs and initiatives across India. The MCPC has the services of over 150 expert trainers from Delhi, Bengaluru, Chennai, Auckland, Maharashtra, Kerala, Punjab, and Haryana. Please forgive my pronunciations. I've been trying to practice, but I don't think I've got it perfect yet. There is no doubt that mediation has had a significant impact on dispute resolution in India, and this is seen in the significant results shown in the settlement of disputes. In fact, there are close to 1,000 mediation centers, over 7,000 mediators trained by MCPC, and since the inception of the project, there's been over 10 million cases referred to the centers, and of which over 1/3 have been settled within the mediation process. Let's just pause for a moment. 10 million cases, and I must confess, this was the information I gleaned up to 2016, so we know it's increased by far from since then. These are significant figures that are encouraging to any mediator or jurisdiction embarking on this path. I personally feel honored, blessed, and filled with pride at the giant steps taken by the Caribbean region, having been privileged to observe its mediation growth over approximately 2 decades. There are several organizations in the Caribbean that have developed and grown. Organizations such as the Chartered Institute of Arbitrators, Caribbean branch, which boasts over 300 members and is comprised of 8 countries, and the Bahamas branch, which is also growing quite rapidly with over 100 members. In the Caribbean, we also have the Dispute Resolution Foundation, affectionately known to all in the region as the DRF. This organization has trained thousands of alternative dispute resolution practitioners in mediation, restorative justice, assisted in arbitration throughout the Americas, and which has partnered with numerous governments and organizations to spread the message of ADR throughout the Caribbean, beyond and onto the global stage. This work has been carried out over the past 30 years and continues to be promulgated. When we speak of ADR in the Caribbean, we must mention names such as the Honorable Donna Parchment Brown, Jamaica's first female political ombudsman, ADR pioneer, and a founding member of the DRF. Just so you know, the Ombudsman is an official appointed by the Governor General by instrument under the Broad Seal after consultation with both the Prime Minister and the Leader of the Opposition. The political Ombudsman has a significant degree of independence and is charged with representing the interests of the public by investigating and addressing complaints and disputes reported by individuals. We must also mention Sir Dennis Barron, past President of the Caribbean Court of Justice and patron of the Caribbean branch of the Chartered Institute of Arbitrators. I'm a strong advocate for ADR. He always says, alternative dispute resolution, no. Let's call it appropriate dispute resolution. And of course, we all cannot forget Justice Lashiz Kokaram of Trinidad and Tobago, who I'm sure you remember from his inspiring address that was given as the inaugural lecture of this great lecture series. And there are a host of other stalwarts that are taking the use of ADR to the next level, all of whom I salute and which their contributions have been nothing less than spectacular. The purpose of our discussion today, I believe it's important for us to step back and take a quick look at the re-emergence of ADR in the Caribbean region, and which forms an integral part and contributes significantly to the fabric of the Americas. I say re-emergence because the use of mediation techniques is not unfamiliar to us. We are familiar with the elders and the panchayat system of resolving disputes in India, to the similar practice from time immemorial in tribes on the African continent, and also in most indigenous groups throughout the world. Mediation was spearheaded in the Caribbean by the Dispute Resolution Foundation. We partnered with other organizations such as Capital University in the United States and the Canadian International Development Agency, CEDA, to push for ADR to be meaningfully brought to the fore, initially in our judicial systems. The DRF was unique in that it was born out of an effort between the Jamaican Bar Association, the oldest bar association in the region, the judiciary, the Ministries of National Security and Justice, and the private sector organizations of Jamaica. So we can see that from the inception, there were major stakeholders in Jamaica's societal development that were involved in the laying of the foundation and groundwork of mediation in the society. The region also welcomed organizations from other jurisdictions, such as the Chartered Institute of Arbitrators. When we formed the Caribbean branch of the Chartered Institute of Arbitrators, we were mining and digging in the trenches as we sought to bring other ADR techniques, such as arbitration, out of the shadows and into the light. The Caribbean team worked in unison, and from the Jamaican chapter, the Caribbean branch of the Institute was formed and now has over 8 countries within the branch: Jamaica, Trinidad and Tobago, the Twin Islands, St. Lucia, Barbados, St. Vincent and the Grenadines, Guyana, Cayman Islands, and the BVI, British Virgin Islands, and has sponsored the Bahamas from a chapter to a branch in its short life. Over the past 30 years, the growth of ADR in the Caribbean has been phenomenal. The DRF and the Chartered Institute of Arbitrators, along with other organizations, have contributed greatly to the advancement of mediation within the Caribbean region. Now, we must recognize that the mediators are in a unique position in that we are in an industry where we are obligated to offer mediation services and to partner with like-minded regional organizations. I believe that the key to the continued future growth of mediation is to be able to adapt and ensure that mediation becomes a catalyst for change in culture. That's how we as human beings commit to resolve our disputes. I would go as far as to say that any forward-thinking jurisdiction in today's current climate, given the challenges and pressures facing our youth and communities, the pre-pandemic number of backlog cases in court systems, the difficulty of conducting business efficiently, and the lack of ease of access to justice, especially as we enter the post-pandemic era, must recognize the importance of mediation. Let us now look at the significant role that mediators can play and what we bring to the table. Firstly, we must realize that mediators are members of a worldwide family of ADR practitioners and who are able to stay on the cutting edge of their craft. Through such organizations like the Navarran Mediators, the Chartered Institute of Arbitrators, and the DRF, their access can be gained to highly trained and experienced mediators and arbitrators. These ADR practitioners have access to the latest techniques and methods and are able to provide first-class mediations and ADR services within their respective regions. The ADR industry globally continues to grow and benefit from mediators who are involved in writing papers, contributing to local and regional landscapes with their thoughts, ideas, and of course their hard-earned experiences. We must recognize that we are just beginning to solidify the culture of ADR, in particular mediation. So how do we continue to cultivate the use of mediation as practitioners, you may well ask? Well, mediation should now be evolving into the next stage and branching out from the success that is evident within the legal systems. What do I mean specifically by this? It's time for ADR organizations and practitioners, perhaps through organizations such as the Navarran Mediators or other groups, to review the successes of their endeavors and apply the methods, skill, and experience gleaned and further contribute to other areas of society. Other areas of society that are screaming for mediation type skills and dispute resolution techniques, and that which over time will yield dividends that no amount of litigation could ever hope to provide. And specifically speaking of the areas of education that will affect and have a direct impact on our youth, a nation's security that will have a direct impact on our communities, justice, which speaks to citizens' ability to access justice quickly and economically, and commerce, where the ability to conduct business can be managed effectively, knowing that the tool of mediation stands ready to be deployed quickly and effectively by expert mediators who may have a particular skill set, knowledge of the area of dispute. The importance of mediation globally with respect to education, security, justice, and commerce cannot be understated. I would like to take a little time to recognize the innovative ways that ADR has been integrated into the fabric of the lives of the Caribbean societies, and that increased use globally can only lead to a global culture that seeks to move away from adversity and which seeks to find collaborative solutions by the use of mediation techniques. I can speak to Jamaica and other Caribbean countries such as the Bahamas, Barbados, Trinidad and Tobago, and also Bermuda, all of whom are strong advocates for mediation. Mediation is a catalyst for change within our global societies who need this. In Jamaica, the DRF has partnered with the private sector organizations and the Ministry of Education and instituted and taught dispute resolution techniques in some school programs. These techniques have been used in programs for children who were suspended from school and joined the school suspension program. These children, after successful completion, are reintegrated into the school system with a new perspective and approach to problem solving. Children who may well have not found their way back from the fringes and may well have gone down the wrong path. Similar projects I see are taking place here in India, or should I say there in India, such as YCM India, India's first youth conflict management and youth initiative. This organization, led by Kujrat Dev, provides much needed support in conflict management skills and young professional skills. In Jamaica and other Caribbean countries, there have been partnerships formed with private sector organizations and the Ministry of National Security to assist, pacify, and prevent flare-ups in volatile communities, to assist in preserving the rule of law. In this example, I'm specifically referring to community-based mediation. Throughout the world, hotspots in countries can be found that can easily flare up for a number of reasons. These areas are usually economically depressed, where the median income is extremely low, and there's an overcrowding with respect to residency. It has been our experience that a proactive approach to community-based resolution and partnering with the law enforcement agencies has yielded positive results and a better understanding between the agencies and citizens, and which has led to a more collaborative approach to dispute resolution. In India, in Bangladesh, mediation has been found to be extremely successful in providing access and delivering justice to the poor sections of the society. This service, I understand, is largely provided by NGOs. The International Mediation Institute in Bangladesh is taking a leadership role when considering all the limitations of the formal court system in the socio-economic context of Bangladesh. It has shown that mediation is a promising alternative for ensuring access to justice, especially for the poor and women. We know mediation can minimize the financial burden and ensure timely justice without creating excessive delays. Mediation has allowed women to access justice without violating the social customs in Bangladesh, since it allows women to discuss their personal and family matters in entirely confidential mediation sessions, which they may otherwise choose not to discuss. In our judicial system, we have included, as part of our legal system, in our Civil Procedure Rules, Part 74, automatic referral to mediation, an option that a number of first world countries are hesitant to take on. By included, I mean that an application must be made to the court to opt out for mediation. This is a tool that allows persons quick access to justice, which is relatively inexpensive and allows individuals to realistically look at the strengths and weaknesses of their disputes and arrive at solutions that they can live with. Sometimes, it's noted, these solutions are arrived at after the mediation session has come to an end, but before the trial. However, it was a mediation process that fleshed out these issues and that led to the resolution and should be credited for initiating that process. I note that commercial courts in India also deploy mandatory pre-institution mediation protocols, which surely speaks to the axis of justice heading in the right direction in your country, all in an effort to make India a global destination for business and investment. In our region, our private sector organizations have also taken note of the importance of partnering with organizations that promote ADR and who can provide practitioners and education, hence increasing the ease of doing business in our country through a quick access to justice. A view of the major regional industries show a number of industries topping the private sector assessment with respect to economic growth and trade performance. And most noticeably, there are strong private sector growth in organizations through the sector-specific representative bodies, particularly in our region in tourism, banking, cement, agriculture, manufacturing, oil, pharmaceuticals, and steel, just to name a few. These are some of the areas that through the sector-specific representative bodies, ADR organizations meet with a view to educating them on what there is to offer, also to seek to form partnerships with them. We as practitioners need to educate them on the ADR advantages, specifically mediation, and how it can be adapted to work with other ADR tools to provide resolutions. For instance, MED-ARB, ARB-MED, arbitration, and/or mediation, all tools that can be deployed. In jurisdictions throughout the world where there's a preponderance of existing commercial contracts that can benefit from ADR, specifically mediation, our organizations should make themselves available to assist in providing sector-specific representative bodies with organizations or links to mediators and other ADR practitioners who may have specific experience and those specific skill sets at reasonable rates. As you can appreciate, this type of private mediation takes the fear of commercial companies, small, medium, and large, facing large mediation or arbitration bills, and at the same time providing regional practitioners with valuable ADR experience. We must embrace initiatives such as the Singapore Convention on Mediation, which aims to facilitate international trade by rendering mediation an efficient and trusted method of resolving disputes, alongside arbitration and litigation. Let us not forget that prior to the Singapore Convention, an international mediated settlement agreement lacked enforceability in of itself. In India, those out-of-court settlements which are prone to rounds of litigations are given way to private mediation between litigant companies where resolutions are quicker and cost-effective. A past high-profile case involving a partnership dispute between the Armachan brothers, a leading law firm in the country, was settled through mediation, through private mediation. Similarly, large family business disputes, contractual property disputes have been settled through the same process. What is of singular importance is that we must share our experience locally, regionally, and whenever possible, globally. We must communicate with like-minded organizations with a view to strengthening ties, increase communication, and encourage cohesive movement of all in one accord, just as we are doing in this forum today. Hence, as we can see, mediation is really a multifaceted tool, an experience that taught to be used at all levels and sectors of society. It must be a cultural changing exercise, and I believe that we as mediators, yes, we as mediators are ideally placed to play our part in this endeavor. I want to talk a little bit about my movement towards the global presidency, role, aims, and objectives. Let me take this opportunity to invite you, my fellow mediators, to stay alert to opportunities. Be willing to voice and bring into action our collective objectives with respect to mediation and our global society. The great proponent of mediation, Joseph Greenbaum, stated that an ounce of mediation is worth a pound of arbitration and a ton of litigation. So let us not be afraid to dream with our eyes wide open. I believe that when we do that, we're in fact sharing our visions. As I move forward to 2023, it is my intention for us, yes, I include all my fellow mediators in my global family, to use the Chartered Institute of Arbitrators Global Presidency platform to exhibit the best of our ideas and methodologies that have been utilized in advancing our mediation efforts. From globally recognized school and education dispute resolution programs to recent innovative online mediations, which has turned our region's online ADR participation inversely. Now, what do I mean by that? That is from 80-20 face-to-face as opposed to online. Before, prior to the pandemic, we were doing 80% face-to-face, 20% Skype. And that has now been reversed in favor of online participation in mediations, and of which I'm sure globally we are all experiencing this phenomenon. I encourage the mediators in India and around the globe to reach out to other regional organizations. Stay in touch with us in the Caribbean. We have so much in common, so much to discuss and foster growth, mutual growth, by sharing your best ADR practices and observing other regions' preferred methods that have set them up for success. We mediators must join our networks, both regionally and globally, and cross-fertilize to infuse our synergies. We will show what I always knew to be true and what has always motivated my enthusiasm, that true strength lies in our diversities. Therefore, it is my aim through this platform to not only improve the ADR landscape in the Caribbean region, but to extend it to the rest of the world. I am challenging our fellow mediators in India, to share your acquired experiences and continue to be known and recognized for your participation and leadership in mediation. So my dear colleagues, what have you brought to the ADR table? What you have brought to the ADR table has enriched us all. Your leadership in programs such as this solidifies the bond between us all as mediators and ADR practitioners. It is my intention to introduce some collaborative ADR initiatives that we can all, as global practitioners, be a part of. Stay tuned. As we can see, in closing, the continued use and growth of mediation in the various sectors of society will inculcate a culture of dispute resolution. This will continue to increase and grow in use, and the importance cannot be overstated. We are already seeing the normalcy take effect around the globe. In America, mediation is becoming the norm of dispute resolution, and litigation the exception. In England, the courts do not award costs if a litigant has unreasonably rejected mediation as an alternative dispute resolution mechanism. The pandemic has forced the practice of mediation to be accessed online and fostered an increase in participation. So what does this mean? We have the tools, we have the desire, and we have the plan. So now let us implement. The result can only lead to a further acceptance of this great tool mediation, and its use will benefit the citizens of the globe in the key areas of youth, development, justice, and commerce. In closing, again, I thank you for affording me this opportunity to address this distinguished group. May God bless the efforts of the Nivaran mediators of Supreme Court of India and all mediator practitioners globally. Thank you and namaste.
Thank you so much, Mr. John Bessie. That was really very informative and encouraging, motivating for each one of us. Mr. Santhanan, sir, I think we don't have much of questions. I must acknowledge the presence of Mr. Charlie here with us, Judge Halim from Bangladesh, and many others joining us today for this webinar. So you rightly said, yes, mediation is catalyst of change, a global change, a cultural change, certainly, sir. Since we are missing with anything towards the question, sir, may I please ask you to please share one of the live experiences of yours which can justify and reflect the quotation you've just used: ounce of mediation is worth a pound of arbitration and a ton of litigation. Can you recollect any live experience which really fits in well with this very good words quotation by one of our very good person, amazing personality? So kindly, sir, share some live example which may motivate us and which may be useful for us.
Okay. For me, as a mediator, every mediation has its peculiarities. Caught me off guard because each one is very special to me. And as mediators, you can appreciate, you throw yourself into that particular mediation. One that comes to mind in terms of an ounce of mediation is worth a ton of litigation is a family business. And it was really a family. It was a mother and father who were in fact separating, but they had an enormous amount of assets. And they had children who very much loved both parties, who were adults and wanted at least to have an amicable solution. The mother wanted to ensure that the father was taken care of because he had illnesses, problems with his illnesses. The father wanted to ensure that the children were taken care of in case anything happened to him and the mother's new relationship didn't get involved. So it's a matter of, yes, it was one mediation. The cross purposes that were in there was at least 10 mediations taking place, despite the commercial aspect of it. At the end, what brought me satisfaction was that the lawyers decided to step back and allow me to mediate with just the parties. Just within 2 hours, we were all happy with what they've agreed. We were happy that the lawyers were able to step back, and they were happy with the mediation process. They went as far as to say that they're going to review all their business contracts to ensure that mediation is a part of it. So I can say from a personal experience, I've experienced it, and as a mediator,
Wonderful. Pravina, we have one question, I think, in the chat box, if you can pick it up.
Yes, John. I would like to ask you that what are your comments on the success of electronic mediations versus physical mediations, and how have you experienced in your career in mediation? If you can just elaborate on it.
Um, when the pandemic hit,
Yeah.
I was very concerned because I thought mediations, how are we going to do them? We can't do face to face and what have you. So I immediately, not
Yeah.
because I'm a tech person, I'm not a tech person, I'll tell everybody that, but I immediately embraced it. I embraced it. I had to because I had to mediate. And good thing is this, that everybody else embraced it as well. So
Yeah.
my has been really good. I do about 90% online mediations now, as opposed to previously face to face. I found that my success rate is just good. I say this, that there are times when you must do face to face, because
Yeah.
at some matters, you do need to do the non-verbals, and you do need to actually see the synergy between the persons. And those are far and few between, but they are also very important. You must know when you need to do that.
Yes, I did have some experience while mediating through technical gadgets, and I found that someday down the line we all can adopt that. There's one more question I would just put to you, John, that you mentioned that we as a global family of mediators should stay alert for opportunities. So, what are those opportunities which we all mediators should look for to spread the word of mediation?
Okay.
Yeah.
Mediation, without getting too deep, mediation for us really is a way of life. We don't take mediation out and put it back in a box in the morning. You're constantly utilizing your mediation skills, and knowingly sometimes and unknowingly. So we must be aware that there are areas we're going to come across where we can utilize it. We're all in areas, whether it be at our groups, our family, wherever it is, where we can utilize and spread the type of that type of dispute resolution technique, and be aware of those opportunities. Also be aware of opportunities that may come globally too. I'm in
Oh,
an organization, I'm in an organization on a platform, but I don't believe that platform is for me by myself. It's for all of us. We have a lot in common. Our jurisdictions share a lot of issues the same way. We need to talk in one voice. These are sort of opportunities that I'm hoping that you'll join with me as we work together.
okay, great. Thank you. Pushpa, I think there is another question you would like to take.
Let me just check. Where is this?
There is a question, John.
And how does, yeah, yes, Praveen, I can look it. It's a question from Amarjeet Prakash. Uh, wants to know, how does mediation differ from arbitration?
Okay. Mediation is it's actually a practice of bringing your third party neutral, and you are not making any decisions. What you're doing is assisting parties or facilitating a conversation so that each side can better see the other side and together come up with a solution that they are able to live with. Mediation, people don't always get what they want. They may have to give up something to get something, but they walk away from the table usually quite satisfied. In arbitration, you are operating with a book of rules. You are told these are the rules, these are the guidelines, these are your terms of reference. We are going to present our case to you, and you are going to facilitate the whole process, and at the end of it, decide what you write within your terms of reference. It's almost like the private court. Those are the basic concepts.
So there is one last question, John. And since in your talk, I heard that you are quite passionate about the introduction of mediation in schools and to the children, especially at the young age, so that they imbibe the same into way of their life. And this question is from Charlie Young, and he asked that at what level should the mediation be introduced for students in school, colleges, or in law courses? Your take on this?
Thank you very much for the question. I'm very passionate about it. I have seen in Birmingham where they have school programs for children in kindergarten, basic school, all the way up to high school. Run by Fiona, who is the wife of Jeffrey Elton, past president of the Institute of Arbitration. Noticed children able to other issues. With the problem, so they will find a mediator in a year. The stuff taught a different way of dealing with problems. Of course, we have different issues, program politics, but that's one way. Of course, in our region, we have our school program. We have children taken in, which
Yeah, thank you so much. We have another one from Mr. Mebel Mutia. How far mediation is effective in criminal cases? Maybe you can answer from the perspective of your country. How is it like in criminal matter? How effective is mediation?
Look at our court systems, I think is very effective. We have a 60% settlement rate, 60 to 70% settlement rate within our court systems. But remember, and I mentioned in my address to you, that's what's the mediation process. In our region, you have after we have had our mediation, you go to case management, and you go distance before you get to trial. By that, issues have been sorted out and have been fleshed out, and usually parties will celebrate long before getting to trial. Those figures, I think, ought to be accumulated with the mediation figures, which will make it higher. So, quite successful, and people are moving towards it.
Thank you, John. We must mention that we have with us Mr. Gregory, President of Law Society of Singapore, and he has written in the chat box a compliment for you, Mr. John, for this timely and thematic lecture on behalf of everyone here. So it was really insightful. And Mr. Gregory, thank you so much for joining us. Pravina, we have one more, if you can pick up.
Yeah.
One more question in the chat box. Yes.
Yes, John, there is another interesting question, and it goes like this: how to initiate the parties to the mediation before going to court litigation? Can anyone approach methods, or are there to meet the parties? So can you just take that? Yes.
All right. I believe in my discussions with a holistic approach, and part and parcel as an attorney as well. When you have your parties and you take on a client, you must let them be aware of mediation.
Right.
And possibly they want to do mediation before even going to court, because can be resolved at mediation. When you get to court, you can tell the court you tried mediation. So I think it's very important as attorneys and practice mediation to people.
Thank you, Mr. John. Before I invite my friend Praveena to deliver vote of thanks, we can quickly take one last question, though we have one or two more. If we can pick up one more by Mr. Ambrose Philip. He wants to know the comments, further comments on non-verbal communication and expressions in electronic media. That is really very interesting thing. It's always debatable how effective is communication in online dispute resolution mechanism and physical. So, sir, your comments on non-verbal communication in electronic medium.
Is the question, what are my comments on online dispute resolution?
Yes, he wants to know on non-verbal communication expression. We basically want to know the effectiveness of non-verbal communication in electronic medium. Because we genuinely here, I have felt in last 1 year, though we've been doing online dispute resolution, but if given a choice to me, I would still prefer physical mediation session over online dispute resolution. So what's your take, John, on this?
My take on it is, I don't mind online dispute resolution online, and at the same time, like I said before, there are times when you do need to go face to face. If you're in the middle of a mediation and it doesn't seem to be going quite right, you know pretty soon whether you need to take it to face to face or adjourn the meeting so you can come back. It could be distractions. It could be a number of different things. Plus, you should have good communication with if they've got attorneys to ask the attorneys what's happening. Don't you think with your client? A number of different ways of dealing with it. So there are a number of tools out there that you can effectively use to decipher whether you need to stay in the online process or move to face to face. Remember, everybody there usually wants to come to some sort of resolution. Maybe not the same one, but some sort of resolution.
Yes, thank you, John. Over to you, Praveena.
Thank you,
to
Push.
deliver vote of thanks. Thank you.
Thank you, Push. Thank you so much, John, for joining us on this webinar, accepting this invitation. My senior colleagues, friends, ladies and gentlemen, I believe that all of you enjoyed this webinar on the topic of importance in global societies with respect to education, security, justice and commerce, just now delivered by Mr. John Bessie. It is indeed my great pleasure to have him as the guest speaker, that you had fruitful discussions, though I think an hour's time is not enough for such a vast topic which has been so aptly summed up by him in a limited time of half an hour. Here I must quote the Secretary General Antonio Guterres, who during the debate of a Security Council in United Nations sometime in October 2018 has quoted like this. I just quote that the United Nations must be bold and creative in harnessing the avenues and capacities available for mediation, and we must make prevention our priority by investing in mediation, peace building and sustainable development. Communities must come to terms with the history and learn to disagree well. I unquote. And I believe that we should all be committed to more effective use of mediation globally and imbibe this as a way of life in our children right from their childhood to build more peaceful world around, and which is a very pet project with John in heart of his heart. And I'm really thankful for this webinar from the bottom of our hearts. I would also like to pay my deep respect, gratitude, and big thank you on behalf of the entire team of Nivaran to Mr. Bessie for having accepted this invitation to be a guest speaker despite his busy schedule. I also thank you to all the distinguished participants, including Charlie Young from USA, Gregory Vijayendra, the President Law Society Singapore, Justice Halim from Bangladesh, and many more participants across the world and India. So I am very thankful on behalf of the team of Nivaran. I hope that all of you must have enjoyed and have some takeaway or the other from the topic of discussion we had today in this webinar, which has certainly widened our horizons of mediation with this global approach. I must also express my big thank you to Rahul, who's working behind the scenes, assisting us ably to make this webinar successful without any technical glitches. He's a brilliant student of law and is not only a tech-savvy boy, but has a keen interest in mediation too. On behalf of Nivaran team, Mediators Supreme Court of India, I would like to express my appreciation to all the participants for taking their time out of their busy schedules, and especially Sheila Balsari ma'am sitting right behind before us. I would like to close my remarks and announce the end of this webinar. Wishing you all the future prosperity and good health to all the participants. Thank you so much, John and the other team. Namaste.
Thank you so much. Thank you. Thank you, John.
Thank you, John.
Thank you for having me.
Thank you, John.
Thank you very much for having me.
Thank you, Praveena.
Thank you. Thank you, sir.